Legal News 1st January 2017 to 7th January 2017 by Deepak Miglani. Death by mosquito bite, an accident, insurer must pay up. National Consumer Dispute Redressal Commission. Ad hoc hiring in a university, a disease. Punjab and Haryana High Court. Supreme Court oust BCCI President and Secretary will appoint panel to run cricket board. Candidate using religion, caste, race, community to seek votes can be barred. Supreme Court. Government again rejects collegium picks for Allahabad High Court. Supreme Court warning on ordinance fraud. Supreme Court bar on contempt cases in lower courts. Government plan law as attacks on doctors by patients can rise. FIR against Bharat Forge after liquor bottles found on its jet. Supreme Court to hear plea seeking probe into journalist allegedly paid to write in favor of Augusta Westland. Head constable shoots himself at Supreme Court. PIL in Delhi High Court on the issue, do Jammu and Kashmir High Court judges take oath under the Constitution of India? Direction of making public list of corporate loan defaulters by Supreme Court. High Court of Delhi directs Delhi University to admit disabled PhD candidate. Anna files PIL alleges rupees 25,000 crore cooperative scam wants power probed. Supreme Court directed government to hike pay of army porters. Unauthorized colonies cannot claim protection. Delhi High Court. Supreme Court to hear plea on Kaveri River dispute. Take my husband back to jail. Wife of Naroda Patia convict pleads with Gujarat High Court. Coming up, National Tribunal for Adoption. Justice Virender Singh appointed AFT chairperson. Delhi High Court allowed devotees to use the Pyao near Gurudwara Sisganj Sahib in Chandni Chowk for 2 days. Delhi High Court to hear plea against fee to fund small airports. National Green Tribunal freezes government move to ease construction norms. Give time frame for paper trail in EVMs. Supreme Court tells Election Commission. Private firms collecting Aadhaar data not a great idea. Supreme Court. Kenyan women to be repatriated, not deported. Delhi High Court. Hyderabad High Court bars land acquisition under GOMS number 123 dated 37th July 2015 by Telangana government. Supreme Court grants Supertech realty firm till 20th March to deposit cash of rupees 10 crore. SEBI writes to Tata companies on corporate governance charges. Now news in detail. Death by mosquito bite, an accident. Insurer must pay up. National Consumer Dispute Redressal Commission. The order came on a claim filed by Mosmi Bhattacharjee, who lost her husband in November 2012 to malaria in Mozambique, where he worked in a tea factory. The husband Debashish, a Kolkata resident, has availed of a policy of the national insurance company called Bank of Baroda Home Loan Suraksha Bima to cover death by accidents. He paid a one-time premium for the sum insured, rupees 13.15 lakh, to be paid in the case of death due to accident. But when his widow filed a claim, the insurance company rejected it, saying a mosquito bite was not an accident under the policy and that malaria was a disease. But all three consumer forum, right from the district and state consumer forum to the apex, the National Consumer Commission held the company's stand incorrect. The National Commission observed that the insurer had included snake bites, dog bites, frost bites under the accident category. The Commission also cited Black Law Dictionary that describes an accident as unanticipated and untoward event that causes harm. Ad hoc hiring in a university, a disease. Punjab and Haryana High Court. Miffed over adhocism and contractual arrangements in educational institutions across Haryana, the Punjab and Haryana High Court said such appointments were like disease, subjecting the academia to disrepute. Justice Rajiv Narayan Raina's comments came while issuing guidelines regarding remuneration and working conditions of guest faculty working in various universities and colleges of Haryana. The High Court has clarified that those working as guest faculty in have no right to claim equal pay for equal work, as they were paid honorarium per lecture as per UGC norms. Such appointees would also not be entitled to remuneration during the vacation period, the court said. Guest women employees would also be entitled to maternity benefits in terms of statutory rules, clarified the court. The High Court also advised the universities and colleges to scrap ad hoc arrangements as soon as practicable and make regular appointments without delay. The petitioners had sought directions to the alleged malpractice in the universities' colleges, which relieved them before the vacations and keeps them on tenterhooks that they might not be called again. Supreme Court ousts BCCI President and Secretary will appoint panel to run Cricket Board. The Supreme Court virtually purged India's cricket administration, declaring Board of Control for Cricket in India President Anurag Thakur unfit to head the body for resisting court-ordered reforms. It decided to appoint a committee to oversee the board's function. Ordering an overhaul of BCCI, the court decided to appoint a committee of administrators and requested senior advocates Fali S. Nariman, amicus curiae, Gopal Subramaniam, BCCI, and petitioners, including Cricket Association of Bihar, to suggest names of persons with integrity and experience in managing a similar enterprise who would take over the BCCI's management. Candidate using religion, caste, race, community to seek votes can be barred. Supreme Court. The Supreme Court ruled that seeking votes in the name of religion, caste, race, community, or language by a candidate, his agent, or anyone with his consent would be a corrupt electoral practice, rendering the person open to disqualification. Government again rejects Collegium's pick for Allahabad High Court. The centre has turned down the Supreme Court's 19 picks for the Allahabad High Court yet again, in a departure from tradition that indicates the ugly confrontation between the judiciary and the executive over appointments to the higher judiciary might continue in 2017. Although the Centre and Supreme Court have frequently disagreed over the appointment of judges for the apex court and high courts, the executive had so far as deferred to the collegium if the latter choose to reiterate its choices. Supreme Court warning on ordinance fraud. The Supreme Court held that repromulgation of ordinance without being placed before the legislature was constitutionally impermissible as it amounted by bypassing the legislative body, which was the primary source of lawmaking authority in a parliamentary democracy. A seven-judge constitution bench held that government's decision to bring ordinance can be reviewed by judiciary and said that it was obligatory on the government to place the ordinance before the legislative body for its approval. Failure of the government at the center as well as states to place ordinance before parliament and state legislature would itself constitute a fraud on the constitution. The majority verdict by Justice A.K. Goyal, U.U. Lalit, D.Y. Chandrachud, and L. Nageshwar Rao held that repromulgation defeats the constitution scheme under which a limited power to frame ordinances has been conferred upon the president and governors. Supreme Court bar on contempt cases in lower courts. Sending out a clear signal to all subordinate courts, the Supreme Court held that no other court could initiate proceedings for contempt of the apex court. Setting aside an order of the Delhi High Court convicting senior journalist, printer and publisher of an English daily for a report on former Chief Justice of India Y.K. Sabharwal, the court said that High Court was not empowered to initiate proceedings and punish a person for contempt of the Supreme Court. The High Court had taken suo motu action after the news story was placed before it by advocate R.K. Anand. In its order, Delhi High Court had said that, being a court of record, it can initiate proceedings for its contempt as well as contempt of its subordinate court and also of the Supreme Court. The power to punish for contempt vested in a court of record under Article 215 does not, however, extend to the punishing for the contempt of a superior court. A bench of Chief Justice T.S. Thakur and Justice A.M. Khanwilkar said. Government plan law as attacks on doctors by patient skin rise. Taking cognizance of increasing cases of violence against doctors by kin or attendants of patients, the government is mulling drafting a central law to ensure protection of the caregivers. Following complaints from the medical fraternity, the government had set up an inter-ministerial committee in 2015 to examine such issues and evaluate ways to ensure safety of those who save lives. In its recommendations, the panel has suggested the Health Ministry initiate the process to bring a central act on the issue. The proposed law may have stringent provisions like making any act of violence against a doctor, medical professional, or hospital authority a non-bailable offense. Around 18 states across the country already have such laws in place. However, in the absence of effective implementation, doctors are often left to face the wrath of unhappy kin of a patient. The committee has asked the Health Ministry to frame the Central Act in line with the existing laws in different states. FIR against Bharat Forge after liquor bottles found on its jet. The Directorate General of Aviation has filed an FIR against a leading Indian corporate group allegedly following the recovery of larger number of liquor bottles from its business jet after a domestic flight. DGCA filed the police complaint against Pune-based Bharat Forge, the world's largest forging company that is into verticals like automotive, power, oil and gas, construction and mining. DGCA had found close to 50 bottles on the company luxury Bombardier Global Express aircraft when it flew from Pune to Delhi, a domestic flight in which serving or storing of liquor bottle is not allowed. Supreme Court to hear plea seeking probe into journalist allegedly paid to write in favor of Augusta West land. The court sought the responses of the Central Bureau of Investigation and Enforcement Directorate on a PIL filed by noted journalist Hari Jaising and Will Mule Weather to order a commission of inquiry on the role of Indian media in the case. The Supreme Court has agreed to hear a plea seeking probe against Indian journalists who allegedly received payoffs to write in favor of Augusta West land. The company mired the helicopter bribery case. The court sought the responses of the Central Bureau of Investigation and the Enforcement Directorate on a PIL filed by noted journalist Hari Jaising and Will Mule whether to order a commission of inquiry on the role of Indian media in the case. Jaising, who was represented by advocate Geeta Luthra, was asked by the top court to provide ED and CBI with copy of his petition. Head constable shoots himself at Supreme Court. A 44-year-old Delhi police head constable committed suicide by shooting himself with his service pistol at the Supreme Court premises. Chandpal was with the security wing of the Delhi police and had been deployed at the Apex Court since April 2014. A police officer posted with the Supreme Court security said that incident took place at 8:30 am inside a sentry post about 100 yards from Gate G, which is primarily used for entry and exit of court employees. Public interest litigation in Delhi High Court on the issue: do Jammu and Kashmir High Court judges take oath under Constitution of India? The Delhi High Court has not yet issued formal notice on public interest litigation and is considering whether the plea is maintainable. The matter will now be heard on February 13. The Delhi High Court asked the Advocate General for the government of Jammu and Kashmir as well as the central government to explain whether judges in the Jammu and Kashmir High Court take oath under the Constitution of India. It also asked whether a plea challenging a provision of the Constitution of India that protects Jammu and Kashmir from automatic application of all laws and constitutional amendments can be heard by the Delhi High Court. The bench of Chief Justice G. Rohini and Justice Sangeeta Dhingra Sehgal noted that it found it appropriate to get a response from the centre and the Jammu and Kashmir government since the petitioners alleged that the judges of the Jammu and Kashmir High Court do not appear to be under oath to uphold the Constitution of India. Senior advocate Ravindra K. Raizada, who was appearing for the petitioners, alleged that judges in the Jammu and Kashmir do not take oath to bear true allegiance to the Constitution of India as by law established, and argued that a question regarding a constitutional principle could therefore not be heard before the Jammu and Kashmir High Court. The Delhi High Court has not yet issued formal notice on the public interest litigation and is considering whether the plea is maintainable. The matter will now be heard on 13th February 2017. Direction of making public list of corporate loan defaulters by Supreme Court. A list of corporate loan defaulters will soon be made public as the Supreme Court directed the center to provide a compendium of corporate entities who own rupees 500 crore or more to banks in 4 weeks. A bench of Chief Justice T.S. Thakur and Justices A.M. Khanvilkar and D.Y. Chandrachud brushed aside the RBI's objection in October against making public the list of big loan defaulters which was submitted in the seal cover. High Court of Delhi directs Delhi University to admit disabled PhD candidate. Delhi High Court found Delhi University's admission criteria for such candidates unsustainable, directing the university to grant admission to physically challenged PhD candidate who had secured 63 marks. Justice V. Kameshwar Rao directed the university to grant admission to the petitioner under the Persons with Disabilities category in the PhD program of Department of Buddhist Studies. In the given facts, the petitioner is entitled to the cost which is quantified at Rs 10,000 to be paid by the respondents, the court ruled. The candidate suffering from 77% disability in his lower limbs appeared for a written exam on July 12. Following the test, 47 students qualified, out of which 17 belong in the general category, 9 in the other backward caste, 16 in scheduled caste and 7 in the scheduled tribes category. The petitioner claimed he was the only one to qualify in the written exam in the PWD category. Anna Hazare files public interest litigation alleges Rs 25,000 crore cooperative scams wants powers probed. Activist Anna Hazare has moved the Bombay High Court seeking a CBI inquiry into what he termed a Rs 25,000 crore sugar cooperative factories scam. The petition alleged that fraud had been committed in governance by first burdening sugar cooperative factories with debts and thereafter selling these 6 units at a throwaway price, caused loss of 25,000 crore to the government, cooperative sector and members of public. The petitions also demanded an inquiry by a special investigating team into alleged role of politician into sugar cooperative scam, including NCP president and former Union Agriculture Minister Sharad Pawar and his nephew and former Irrigation Minister Ajit Pawar. The petitions name both members of the Pawar family as respondents. Supreme Court directed government to hike pay of army porters. The Supreme Court has directed the center to pay wages to 12,000 civilian porters working for the Indian Army on par with the lowest pay scale given to the Army's multitasking staff. Coming to the aid of civilian porters working in the high-risk areas like Rajouri, Jammu and Poonch, the court asked the center to finalize a scheme having better pay, medical facilities, enhanced compensation and the severance grant higher than the Rs 50,000 proposed by the government. A bench of Chief Justice T.S. Thakur and Justice A.M. Khanvilkar issued the directions while noting that the porters must be compensated fairly for their work as they provide valuable support to the army. To look at their work from the metrocentric lens is to miss the wood for the trees, the court said. The court ordered that the scheme be finalized in 3 months, disposed of the pleas moved by 29 porters who had contended they were not treated as regular employees. Unauthorized colonies cannot claim protection. Delhi High Court. Dismissing a plea by the Residents' Welfare Association of an unauthorized colony in northwest Delhi against acquisition of land of its occupation, the Delhi High Court, in a judgment, said that such colonies are normally born out of greed with intent to secure unmerited benefits and could not claim protection against demolition. The bench of Justice Manmohan observed that while Jhuggi Jhopadi clusters are normally born out of need for housing of the poor and underprivileged, unauthorized colonies are normally born out of the greed with intent to secure unmerited benefits. Legalizing unauthorized colonies in the past has not only emboldened the purchasers of acquired land and rank encroachers but has created manifold problems of environmental degradation, traffic bottlenecks, etc. The bench also observed that such colonies made it extremely difficult, if not impossible, to create proper civic facilities since they occupied land in a haphazard manner. The observations were made while dismissing the plea filed by the Residents' Welfare Association of Utsav Vihar Colony. The colony, constructed on what was once private farmland, comes in the way of the ongoing project for the Urban Expansion Road 2nd, which aims to create new bypass roads to decongest Delhi under the Master Plan 2021. Supreme Court to hear plea on Kaveri River dispute. A three-judge bench headed by the Supreme Court, Justice Deepak Mishra rejected the centre's stand that the apex court had no jurisdiction to hear the Kaveri River dispute. The Supreme Court will hear a plea regarding the Kaveri dispute as its interim order directing Karnataka to release 2000 cusecs of Kaveri water per day to the Tamil Nadu. The apex court had on 15 December said that the interim order on Kaveri water dispute will continue till 4th January. Take my husband back to jail. Wife of Naroda Patia convicts pleads with Gujarat High Court. Rathod was granted temporary bail on 27 September 2016 for 7 days on the ground of his children's ill health. The wife of a Naroda Patia convict has once again approached the Gujarat High Court pleading to take her husband, who was released on temporary bail for a week but has not surrendered for nearly 2 months, back to jail. The court rejected her petition and directed Special Public Prosecutor to alert the concerned authorities. Minal Ben Rathod had moved the High Court last month requesting the court to direct the police to take custody of her husband Nawab alias Kalu Hari Singh Rathod. Rathod was granted temporary bail on 27 September 2016 for 7 days on the ground of his children's ill health. The bail petition was moved by Minal Ben herself. Coming up, National Tribunal for Adoption. Under the amended Juvenile Justice Act of 2015, no judge should keep an adoption-related case pending for more than 2 hearings spread over 2 months. With a mounting number of adoption cases stuck for years at district court across the country, the centre has proposed that all such matters will now be dealt by a dedicated national tribunal. Justice Virender Singh appointed Armed Force Tribunal chairperson. Virender Singh, former Chief Justice of Jharkhand High Court, has been appointed as chairperson of the principal bench of the Armed Forces Tribunal in New Delhi. As of now, only 7 out of total 17 benches of the AFT are functional across the country. Justice Virender Singh is based in Chandigarh and had been a judge of the Punjab and Haryana High Court from July 2002 to April 2007. Thereafter, he was transferred to the High Court of Jammu and Kashmir. Later, he took over as the Chief Justice of Jharkhand High Court in November 2014 and retired from the post in October last year. Delhi High Court allowed devotees to use the Piao near Gurdwara Sheesh Ganj Sahib in Chandni Chowk for 2 days. High Court allowed devotees to use the Piao near Sheesh Ganj Sahib Gurdwara in Chandni Chowk for 2 days in view of the birth anniversary celebrations of Guru Gobind Singh. A bench of Justices B.D. Ahmed and Ashutosh Kumar granted the relief, taking into account the special circumstances and permitting use of the Piao on Thursday and Friday. Earlier this year, the corporation had raised the Piao on court orders, but it was reconstructed overnight. After that, the court had prohibited anyone from using the water fountain, which claimed as sacred by Delhi Sikh Gurdwara Management Committee. The committee told court the Piao was within the pillar of the Gurdwara and that it was part of a historical structure. Delhi High Court to hear plea against fee to fund small airports. The Delhi High Court agreed to examine a plea by Federation of Indian Airlines challenging the government's proposal to levy Rs 7,500 to 8,500 per flight operated by Indian carriers to create fund to develop regional airports. National Green Tribunal freezes government move to ease construction norms. The National Green Tribunal barred any fresh constructions under the Environment Ministry's December 9 notification exempting real estate projects of all sizes from environment impact assessment and environmental clearance. The NGT bench also allowed the applicant's lawyer to keep a watch on any such constructions coming up and inform the tribunal of the same. You cannot do legal blunders and get away with it, a bench headed by NGT Chief Justice Swatantra Kumar told lawyers representing the ministry. The applicants Pushp Jain and Society for Protection of Environment and Biodiversity have raised different issues. These include the draft notification issued by the ministry on 29 April 2016 being substantially different from the final one. Give time frame for paper trail in electronic voting machines, Supreme Court tells Election Commission. The Supreme Court has asked the Election Commission to spell out the time frame within which it would deploy voter verifiable paper audit trail in electronic voting machines across the country in all elections to make the process more transparent. The paper trail system is meant to supplement the existing procedure of voting and it allows voters to verify their respective votes. Under this system, a printout will come out after a person casts his vote, apprising the voter that his vote has been rightly registered. The printout is to be deposited in a box which can only be used by the Election Commission in case of a election dispute. In October 2013, the Supreme Court had directed the Election Commission to introduce paper trails as allegations were being made from time to time that electronic voting machines were prone to tampering. It said that paper trail was an indispensable requirement of free and fair elections. A bench of Justice Ranjan Gogoi and L. Nageshwar Rao asked the Election Commission to give an undertaking to implement its order and also the time frame within which paper trails would be introduced. The Supreme Court agreed to hear a contempt plea against the Chief Election Commissioner for the Election Commission's failure to implement the Supreme Court orders in true spirit. Private firms collecting Aadhaar data, not a great idea. The Supreme Court declined to expedite the hearing of Aadhaar cases challenging the constitutional validity of the initiative but observed that data collection by the private agencies might not be a great idea. Chief Justice of India J.S. Keher made the remarks after the senior advocate Sham Devan sought urgent hearing of the plea, citing private concerns. The apex court had earlier permitted voluntary use of Aadhaar cards in social welfare schemes such as LPG subsidy, PDS, pension schemes, and provident fund, etc., beside ambitious flagship program like the Pradhan Mantri Jan Dhan Yojana of the NDA government. A five-judge constitution bench had, however, put a caveat that Aadhaar was purely voluntary and that nobody would be denied access to any services or benefits offered by the government for want of it. It had said that a larger bench was required to be set up for the final disposal of the petitions, including the questions of whether the right to privacy was a fundamental right. Kenyan women to be repatriated, not deported, Delhi High Court. The Delhi High Court has issued directions asking the center to repatriate, not deport, a Kenyan woman suspected of indulging in prostitution while she was in the city on a tourist visa. The court, however, clarified that its order would not come in the way of an inquiry conducted in accordance with law. Detained on 7 December 2016, the Kenyan woman moved the Delhi High Court asking that she be allowed to return to Kenya rather than being deported, which would have serious consequences for her. Hyderabad High Court bars land acquisition under GOMS number 123 dated 30th July 2015 by Telangana government. The Hyderabad High Court declared that the Telangana government shall henceforth not purchase lands under GOM 123 dated 13th July 2015 for the public purposes of construction of irrigation projects. The bench took note of the fact that marginalized sections of the society who are dependent upon these lands are denied any benefit, unlike the scheme under the New Land Acquisition Act 2013. These interim orders were passed by a division bench comprising acting Chief Justice Ramesh Ranganathan and Justice U. Durga Prasad Rao in a batch of writ petitions. The lengthy judgment of 80 pages was delivered in case filed by farmers, artisans, agricultural laborers affected due to land acquisition by the Telangana government for irrigation projects. This GO 123 enabled the farmers to sell the lands voluntarily. The government claims that willing farmers will get money more than they would have got under New Land Acquisition Act of 2013. Supreme Court grants time to super tax realty firm till March 20 to deposit cash of rupees 10 crore. Real Estate Supertech Limited failed to comply with the Supreme Court order to deposit rupees 10 crore and told the apex court that it could not raise the amount as it was hit by demonetization. The court had directed the company, which is fighting a legal battle to protect its twin towers at Emerald Court in Noida, facing the threat of demolition, to deposit the amount before its registry by 3rd January 2017 to ensure that flat buyers who wanted their money back did not remain in illusion. After hearing Supertech's plea, the Supreme Court gave it time till 20th March to deposit the money, saying it was the last chance for the developer to comply with its order. The court had earlier said that flat buyers should not feel uncertain regarding their investment as the fate of Twin Towers hangs in balance and made it clear that it would order for their demolition if it came to the conclusion that they had been built in violation of law. SEBI writes to Tata companies on corporate governance charges. The market regulator SEBI has written to the audit committees of 7 Tata companies to clarify on corporate governance lapses alleged by ousted chairman Cyrus Mistry. Separately, SEBI has also written to the 7 Tata Group companies TCS, Tata Motors, Tata Steel, Tata Power, Tata Chemicals, Indian Hotels, and Tata Global Beverages to clarify if they had violated any rules under the prevention of insider trading by sharing board agenda items and strategy documents with the trustees of Tata Trust and Tata Sons. After Mistry was sacked as the chairman of Tata Sons on 24th October last year, he had written to the board of directors of Tata Sons, trustees of Tata Trust, and also the shareholders of the 7 Tata companies about the corporate governance issues. All listed companies, including the directors on their boards, have to adhere to strict corporate governance rules. SEBI has not started any formal investigation on the basis of Mistry and Wadia's allegation of violations of corporate governance and insider trading rules. Thank you. If you have any query, please feel free to contact us at legalbuddy@gmail.com.